you, Joe, for those kind words. And I would just like to preface and say, as a district attorney, our job is not about locking people up. Although sometimes it is, depending on what you then did. But that's not all that we do. And what I'm going to do today is basically give you an overview of cases and how they get filed at the district attorney's office. And in doing so, I'm going to tell you about some resources for victims of crimes that you may not be aware of. Now, I want to preface by saying I'm speaking in general terms. I'm not here representing a specific case or to talk about any specific jurisdiction. Everything I'm telling you is general information, and every DA's office handles things differently, but the functionality is similar between all of them. So if you've had the unfortunate circumstance of being a victim of a crime, I myself have, you often wonder, if you report that crime and the police get involved, what happens when it goes to the DA's office? Well, first, just to tell you, the police, they write a police report, take down statements, things of that nature. Then what they do is they'll submit a report to the DA's office. And when we get that report, what we do is we take an independent review of that report, and we then decide if we feel there's evidence that a crime was committed. And I'll tell you, even though we work hand in hand with law enforcement, we don't always agree. So sometimes the police can be very zealous, arrest someone, submit a report, and all excited and gung-ho about someone possibly getting prosecuted, and they'll bring the report to us, and we may look at it and say, nah, nope, we don't think a crime was committed. Sometimes we may think a crime was committed, but there's not enough evidence to prosecute. And sometimes when that happens, if you're a victim of a crime, you may not become aware of that right away. And normally what happens is when we're reviewing cases and we're trying to figure out if a crime was committed, and secondly, if there's enough evidence to prove that in a court of law beyond a reasonable doubt, if we don't have that at the initial stages, then that case can get rejected and flat out not filed. Or sometimes we can send that case back and tell the police agency to do further investigation. And we know everyone's busy, overworked, and understaffed. So unique to the DA's office is that we have our own set of internal investigators who also assist us with collecting evidence on cases and helping us in the initial stages in filing cases. Now, if you're a victim of a crime, sometimes we hear victims say, well, I know the police were called out, I know a report was sent to the DA's office, but we don't want to file charges, or we don't want the case to proceed. And it's a common myth that if a victim doesn't want prosecution or want the case to proceed, they can call us up and say drop the charges. And oftentimes we have to tell people that's not how it works. Unfortunately, once a crime is reported and it comes to the DA's office, if we feel there's evidence to support that crime and that we can prove it in a court of law, we can proceed even if the victim doesn't want prosecution, even if they change their mind later on. And this happens quite frequently. Most of the time I see it in like domestic violence type cases where a victim reports an incident and later on they have a change of heart and they don't want their partner to be prosecuted. And we have to tell them it's out of your hands once it gets to us. And we will proceed on that case with or without them. And it's different, I want to tell you, in different jurisdictions. Because I know in our more liberal areas up north, sometimes some of those offices, if the victim doesn't want to participate or doesn't want prosecution, sometimes they'll say, well, they don't want to deal with the headache, and they'll just let the case go. But down here in Southern California, particularly in the Inland Empire, we'll proceed without you. Now, once a case does get filed, just so you know, the DA's office and not the police determine what the charges should be. And also, we're the ones who make initial offers and decide things like what we think a person's punishment, if the case is deserving of punishment, should be. But some things that you should know if you are the victim of a crime is that if it's a crime involving violence or a serious offense, you can get what's called a victim rights advocate assigned to you. And sometimes victims are not aware of this, but it's a person who's basically like a liaison between the victim and the DA. And a victim rights advocate, normally what they do is talk to the victims. They do practical things like talk to the victims about coming to court, educate them on the process of when you have to testify. They help them with logistic things, where the courthouse is, what to wear to court, when to be in court. And they also go a step further if victims don't have a way to court. And this applies to victims and witnesses. Our advocates will go out, pick them up, bring them to court, take them back home. Sometimes we have victims who are homeless. Our advocates will get them clothes if they need it for court. We'll put them up in temporary housing while proceedings are pending, if it's a hearing where they need to testify at. And advocates can help with things like if victims need food, like providing meal vouchers. They also can help with other resources. And these are things that victims of crime may not be aware of because the police agencies don't normally tell them about it. And unless you contact the DA's office or we contact you, you may not be aware. A unique new program that they've started in the Inland Empire in the past couple of years is having support advocates who are actually canine victim support animals. And these are our four-legged friends who have served their time normally helping with police agencies, and they're in retirement mode. They come over to the DA's office and they get a second lease on life. And what they do is sometimes when we have, for example, child victims or victims who have PTSD or who are really afraid about coming to court or the whole process, we'll introduce them to the canine support animals and we'll have them interact with that animal over the course of weeks or months to help them feel comfortable about coming to court. And our canine friends, they will often sit with a victim while they're testifying in court on the stand on matters. Another thing we hear from victims and witnesses is that they don't have to show up to court if they've received a subpoena. And that also is a myth. I get angry calls all the time. I got a subpoena, but I'm not coming. And I tell them all the time, if someone handed you that subpoena, that piece of paper is a court order. And there's a lot of power behind it. And I often tell them, whether you want to or not, you need to abide by that subpoena and at least show up to court. Now, when you get there, nobody can make you talk, nobody can make you do anything, but you're going to have to show up. And I often tell people, if you don't show up, then that paper, the power behind it, can cause you to get some handcuffs put on you if you don't abide by it. So if you're a victim or witness and you're served with a subpoena, show up to court. Now, while your case is moving through the court process, victims have a right to be involved along the way. But when we're talking about things like punishment and case resolutions, sometimes victims may feel like they're not given a full voice. And that's because when we're resolving cases and doing negotiations, sometimes the DA doesn't directly involve the victim. And I want you to know that in California in recent years, there have been a lot of changes to our criminal justice system and how cases get handled. And it's not like it was before, where you saw people getting decades and a lot of years in prison for nonviolent offenses or for drug offenses. Nowadays, the majority of the people who serve long prison sentences are people who get convicted of child molestation, murder, very serious and violent offenses. Recent changes in the law for people who are eligible for probation. And these are people who are not going to prison, but for misdemeanor offenses, where you're looking at a year or less in county jail. Previously, you used to be able to be on probation for up to 3 years. The laws have changed, and now if you have a misdemeanor conviction, you only serve probation for 1 year. And for felony offenses, where it used to be up to 3 years or more, your probation is now only 2 years. And this doesn't apply to crimes that are serious or violent. Okay? But low-level felony offenses, minor offenses, the probation time has been greatly reduced. Also, sometimes victims may want to know, well, the defendant has admitted that they committed a crime. Why aren't they in jail? And sometimes what we've been seeing is that for certain types of defendants, there's been a shift in how their cases get resolved. And we've seen more DA offices working collaboratively with the courts, defense attorneys, social service agencies like like Veterans Affairs or behavioral health, and trying to help people who've committed crimes get treatment versus incarceration. And I'm going to highlight a couple of those programs. Some of the programs that we offer that are in lieu of a person actually getting incarceration time is mental health court. And that's a particular court that's designed for people who have a diagnosed disorder or mental disease that was a contributing factor to their criminal activity. And in a mental health court, instead of a person getting punishment, what we do is offer mental health treatment to try to help them so that they don't come back and reoffend. Along those lines, we have another program called Veterans Court. And that's for any veteran or active duty military person who's been discharged. And normally we only take honorable discharge, but in certain situations, they'll take a dishonorable discharge from the military. And if that person committed a crime and it relates to some type of disorder, mental health condition, psychological issue that they obtained while in the military or is connected to their military service, then they can also receive treatment in lieu of incarceration. Another program we offer is the diversion program. And that's a program where instead of going through the normal criminal justice system, a person can do alternative programs like anger management or get treatment. And when they're done with that program, their case gets completely dismissed. And even though the majority of the drug crimes now are not crimes, are there misdemeanors, we do still offer drug treatment programs for people who committed offenses that are connected to a drug addiction. And the benefit of all these programs I mentioned is that if the person successfully completes it, they not only avoid incarceration, but they have their cases completely dismissed. Another program that is new to the Inland Empire area is the Homeless Court program. And that's a program that was implemented a couple years ago to try to help homeless defendants clear up their cases. A lot of times with the homeless, they'll pick up cases daily for things like drunk in public, trespassing, low-level minor infractions, starting fires to try to keep warm, and things of that nature. So they've implemented homeless court where they'll have judges actually go out sometimes to shelters, or they'll have special sessions where homeless people can come in and have those minor violations cleared up off their record. So there's been a lot of changes in how we handle certain types of defendants. And victims may sometimes wonder why they're not in custody, but if they meet these certain conditions, then we think that this is a better alternative than just putting someone in custody and them getting out and repeating that behavior. Now, when we are evaluating whether or not someone should receive custody time or incarceration versus treatment, we still consider public safety, and we also consider the impact on a victim. Now, what are a victim's rights when it comes to that process? I'm going to highlight a couple of them for you. When a defendant is being considered for one of the programs I mentioned, for example, if you're a victim of a crime, you have the right to come to court and be heard about whether or not that person should be allowed to enter that program. You have a right to be present at all the proceedings and to see and hear what's going on that case. And I want to just say that sometimes people think that because they're a victim, they don't have any power. But I tell victims all the time, sometimes what you say in court has more power and influence than what I say, because the judges see me all the time and they hear my mouth all the time. And when a victim comes in and they talk about how something has affected them, it does have power. And sometimes it can actually affect what a judge does on a case. Sometimes a person may or may not be able to get into a program based on the impact that they've had on the victim and what that victim represents when they come to court. But if you are the victim of a crime, one of the rights that you have is what's called Marsy's Law. And that's known as the California Victims' Bill of Rights, which was established in 2008. And what that law does is it gives victims of crime about 17 constitutional rights. And they're listed in our state constitution under Article 1, Section 28B. But just to highlight the most common ones, as I mentioned, it gives you a right to be heard and present in court. It also allows for you to have return of property, property that may have been confiscated by the police during an investigation. Sometimes we'll have cases, and cases we know through our system it does not move fast. Cases take months, sometimes years to get resolved. And sometimes victims will have very important property, money, cars, phones, computers, things that law enforcement took as part of their investigation. And before, victims have to wait until the whole case was over, no matter how many months or years it took to get that property back, if at all. But under Marsy's Law, they can petition the court to have property returned to them. It also entitles a victim to receive notification when a case is over and if a defendant is incarcerated, if that person is up for parole. And that's really important because victims now have the right to be present and to give statements at parole hearings on their opinion about whether or not someone should be released from prison. They also have the right to receive notification if parole is granted, even if it's years and years after the case is over. Marsy's Law is really important because when a case is being resolved, we oftentimes cannot even sentence a defendant unless we've given a victim the right to be heard. And if a victim says they want to be present or make a statement, then we have to wait. We have to wait for them before we can proceed with the case. Also, as the DA's office, we're tasked with locating victims. So when I told you those cases take years and months to resolve, if we've lost contact with a victim, we have to actually try and find that person to let them know that the case is going to be resolving. One of the other big rights that a victim has is the right to restitution, basically to be made whole again. And restitution applies whether or not a defendant is in custody, out of custody, on probation, or receives a prison sentence. Sometimes I'll have victims say, well, if they had an economic loss, they often ask, am I ever going to see any money? The defendant's going off to prison. What does it matter? And I tell them it matters because even though a defendant may be in prison, they earn anywhere from, on the low end, 14 cents a day up to, I believe, $2 a day. And that's very low money in the real world, but a victim is entitled to that money. So if someone's in prison earning money, any money they earn, a portion of that gets paid to victims if they've requested restitution. And when that person gets out, I think it was a few years ago in the news that someone had went to prison, they owed restitution, and I think they got out and won the lottery. Guess what? because the victim had a restitution order, they got that money. So it's very important, and I tell victims, don't think, oh, this person doesn't have the ability to pay now, I'll just let it go. Don't let it go. Some of the things you can receive restitution for are, of course, any out-of-pocket expenses, economic loss. If you've been physically injured, that can include medical bills, things of that nature. But you can also receive restitution for things like lost wages from work as well. Lastly, one of the other rights that victims have that they may not be aware of is under the California Victims Compensation Board. It's a government-funded program that provides immediate financial assistance to victims of crimes. And it typically applies to victims who've had some type of emotional or mostly physical injury resulting from some type of crime of violence. And what that board does is it will pay out money to a victim while the case is going on, before it gets resolved, and even after a case gets resolved and the person gets convicted. And I tell victims about this because sometimes in our most serious cases, like murder cases, we'll have families call up crying because their loved one has been killed and they don't know how they're going to bury them. Well, the Victims Compensation Board pays thousands of dollars to help bury people. Other things that the board pays for are therapy, treatment. The board also will cover things like if, say for example, your home was burglarized and you were home when it happened. You still live in that house, you don't feel safe. They'll pay to have a security system installed in your home. They'll pay to have cameras installed. If you need to move or relocate because of a crime, the compensation board will pay to move you and your family to a new home. They also offer things like crime scene cleanup. Unfortunately, in some violent crimes, there may be a bloody crime scene. When the police are done, they don't clean up that blood, they just leave. It's up to the homeowner, the person who lives there, to have to deal with that mess. They also pay for things like service animals. They also cover things like lost wages. And they provide support for legal dependents if their parent or guardian was the victim of a serious crime. So they provide a lot of resources for people who need immediate assistance. And all it takes is just filling out an application, being a California resident, or the crime occurred in California if you're not a resident, and you can submit that application at any time within 7 years of that crime occurring. So it doesn't even have to be right away. It can be after the fact, and that money is there. So basically, in conclusion, I want you to know we're not here just to lock people up. And if you are the victim of a crime, just know we are here to help you, and there are resources available for you. Thank you.